faculty of the University of Brawijaya in 2009. So in this, the last series of the 3-in-1 guest lecture, the topic would be about free speech on the international human rights law, or free speech on international law. So what have been understanding, or I've been told that you are on the 6th semester, if I'm mistaken, or maybe there's other that come from uh, higher or even lower semester or batch. But I believe that you already know the basic of international law, or at least understanding about the human rights law. So I'm not going to talking that much on the part of the basic introduction. And it is also have been discussed in the previous 2 days of this program. However, I might be still talking a little bit more to give to refresh your mind, just in case. So let me do the share screen for this lecture. Okay. So Free speaks on international human rights law. Just a disclaimer. So later on or going forward, you might be hearing I'm saying freedom of speech, or I'm using freedom of expression. Those two terms I will be used that maybe interchangeable. Maybe I will use that interchangeably, because actually those two terms are not having any significant differences. Um, Despite that, in the ICCPR itself, or International Covenant on Civil and Political Rights, there are some scope that this is freedom of speech and this is freedom of expression. But generally, I can say that it's actually pretty much the same. But here goes for the topic that we are going to discuss about freedom of speech on international human rights law. So it will be based on the treaty itself. On the first day, I talk about UDXR, how then it stemmed from UN Charter in 1945, and then UDXR, or Universal Declaration on Human Rights, in 1948, and then ICCPR in 1966, along with ICSCR in the same year. So all of those three treaties, UDXR, ICCPR, and ICSCR, is commonly called as the International Bill on Human Rights. Of course, when we talk about human rights, it will be divided into two major areas, because there are civil and political rights, and also there is economic, social, and cultural rights, which is regulated under the ICSCR. Free speech itself is actually part of the civil and political rights. That's why then on this slide you can see that it stands from Article 20 UDXR. It says that everyone has right to freedom of opinion and expressions, and so on and so forth. And it was then transitioned to the Article 19 on the ICCPR, which actually saying similar thing, that everyone shall have the right to freedom of expression, and the scope of it, which include freedom of seeking, receiving, and impart information and ideas of all kinds, regardless of frontiers. What does that mean? It means that nobody should be getting, or nobody should get any interferences whenever they are going to searching information, receiving information, or disseminating information and ideas in any kind of medium. So right now we have internet, we have any kind of media, social media, internet itself, newspaper, radio, television, and any other medium that you can think of. It's actually protected under the ICCPR. Indonesia itself, as the country, is already ratified this convention, ICCPR, in 2005. Therefore, we can say that Indonesia is a state party of ICCPR, and also Indonesia should also comply, or being obligated to the human right obligation, because the country is a state party of this ICCPR. So this is like the basic of the the treaty, from the treaty. So when we talk about free speech as part of human rights, I have to talk about this a little bit, even though the main issue is actually, the main topic today is on the Article 19, freedom of expression or freedom of speech. But to give you some a little bit broader context, freedom of speech would not be, it is actually inevitably connected with other freedoms: freedom of religion or belief in Article 18 ICCPR, freedom of assembly in Article 21, and freedom of association in Article 22. Four of freedoms. This one on Article 20 is actually about war propaganda and hate speech. It's actually connected with the Article 19. It has become a separate provision or separate article in Article 20 because some scholars says that Article 19 is still less generalist, and while Article 20 is the lex specialist. So it's more specifically talking about war propaganda, glorifying terrorisms, denying about crime, or like Holocaust or something like that, for example, and hate speech as in racist hate speech. So that's why it's called it is regulated under a specific or more specific provision under Article 20 of ICCPR, which then still part of Article 9, still part of the provision of freedom of expression, but it should be separately regulated. So as I said, it will be connected each other of this freedom of religion, freedom of expression, freedom of assembly, freedom of association. Let me give you one example. For example, Article 18 and 19. Freedom of religion will be divided into two as well, as in there are internal forum and external forum. So the scope of freedom of religion is actually when an individual, a person who has religion or not, going to express themselves in a public forum or in a private forum. The example of private forum is for any religion. It can be in any religion. So let's say if an individual who has a religion and then he or she practicing a religion, he or she praying in her house, in his or her house, or in a worship place like a temple or something like that, masjid, whatever it's called, depends on the religion. That is actually the part of internal forum of a freedom religion. The external forum is when the person is, teaching or disseminating the idea of the religion, and also wearing or using any religious symbol or clothing. For Muslim or Islam, in Islam would be like a jilbab. For in religion, Sikh religion, people wearing turban on the head. That is actually the external forum of the freedom of religion, which then it is also slightly connected with freedom of expression in here, because those people who believe in religion also expressing themselves by wearing the religious clothes or symbols that it's mandatory for them because they are practicing the religion. So that is one example of the connection between freedom of religion and freedom of expression. Another example in between freedom of expression and freedom of assembly, it's also going to be connected each other. Its assembly is like, one of the example assembly, like demonstration, protests, or students usually are doing demo in front of DPRD or DPR building, protesting about, like, for example, omnibus law or something else that you might be going to protest. The way that you are all of the protesters assembling, it's protected under the freedom of assembly in here, Article 21. But when you gathering in that assembly and then protesting, expressing your opinion, expressing your protest, that is part of Article 19, freedom of expression. Therefore, you can see the connection between freedom of expression and freedom of assembly as well. Freedom of association, I think it's pretty clear when you can form a trade union or like Serikat Buruh, and then whenever there are something unfair policy from the company, you are expressing themselves as well. It's also part of the freedom of expression. So all of these four inevitably going to be connected, and it is difficult to just ignore this part of the explanation, because even though the main topic today is about freedom of expression, but I think I have to briefly discuss about this the relation with all of the four freedoms. Let me continue. The next one is about the scope, as I mentioned earlier on the Article 19. The scope of the freedom of speech, or what is the conduct or the act that can be called or protected under freedom of speech, is that when when someone is seeking information, receiving information, and impart information and ideas. So even though you are passively just listening or receiving information and ideas, it should be part of freedom of, it should be protected under human rights and also part of freedom of speech as well. That's why the second dimension of freedom of speech or freedom of expression is also freedom of the press as well. Because freedom of the press will be play a major role in how then someone can receiving information and ideas over here. How then someone can use the media or the press in here to impart or also to seek information as well. So imagine if the government in any country, if the government put unnecessary censorship to media or to the press, that is actually also blocking or hindering the freedom of speech, which is the scope in here is seek, receive, and impart information and ideas, which then make the problem on the freedom of speech as well. So here is the part of the scope of freedom of speech. Now, with all of those scope and all of those basic on the 3D, I mean the grounds of on the 3D UDXR and also ICCPR. Not to mention there are other regional international human rights law 3D, like in European Human Rights Court, freedom of expression is protected under Article 9, Inter-American Human Rights, I'm sorry, not court, convention, Inter-American Human Rights Convention, which is for American countries in American continent, and also African Benjul Charter, Human Rights Charter. They also have freedom of speech provision or article that protecting freedom of speech article. The only continent that I know, last time I checked, do not have regional human rights treaty is Asian itself, which our continent, which Indonesia belongs to. So far, I never heard it. I don't think Asian has its own of human rights treaty system, which then to some extent is actually challenging and problematic when there are human rights cases or human rights dispute settlement. But I think that's not the part we are going to talk about. Anyway, back to this is that how then it becomes significant? How then freedom of speech become really important in the terms of in the context of international human rights law and protecting human rights? There are several reasons, as you can see here. The first one is about self-fulfillment or expressing yourself. The justification is like this. So if you are believing that everybody should be getting the same and equal information, everybody can advancing their knowledge, their own knowledge, and become smarter or whatever you call it, getting education, then you should also allow freedom of speech to be protected properly. You should also allow them to be self-fulfillment. You should also allow individual and citizen to seeking and receiving and impart information. So in regards of that, for example, if any of the education in education sector, let's say if there is a part of history that is censored by the government, but then it's not in the censorship is not based on legitimate aim, it's actually problematic for the part of the first significance of freedom of speech. For example, transparency and accountability is, I think, obviously, making on connecting with the governments, how the government's policy affecting us. When the government is not being transparent or not being accountable, then we are dealing with the government who is not capable to regulating this country, to making policy to this country, or wherever you are living as a citizen of the country. And then freedom of speech is allowed to allow civil society and also citizen itself, society itself, to looking for transparency and criticizing and analyzing whether the policy by the government, the laws or the legislation made by the government is going to be giving a good effect or even bad effect to the society itself. That's important in terms of the transparency and accountability. Self-government, which I believe also part of the democracy itself. So one of the legal scholars, the popular legal scholar that wrote about self-government, his name was Alexander Meiklejohn in Free Speech his book is titled Free Speech and Its Relation to Self-Government. Well, it is more actually about the First Amendment in the United States, but I think it can be applicable to any jurisdiction in the world, as in the self-government itself. The self-government in here is that, in Indonesia, you can call it kedaulatan rakyat. And in our Indonesian Constitution in 1945, UUD 45, I think in Article 2, it also says that the sovereignty of the Republic of Indonesia, it lies on the hand of the people, the society. It's on us. It's actually similar with actually equal with the self-government here. So that's the significance of the freedom of speech, and then we connect with the democracy itself, which is all the people equal, and a fair and free and fair election, and so on and so forth, and then how then all of this makes the significance of the freedom of speech. However, as you may know, when talking about human rights, there are some human rights that is dirigible, and there is also human rights that is non-dirigible. And freedom of expression or freedom of speech as human right is not an absolute human right. Government can derogate freedom of speech as human rights whenever the expression or the speech going to violate all of these grounds, whether the expression is not respecting other people's rights or the reputation of other people, national security, like terrorism, or glorifying terrorism, supporting terrorism, treason and sedition, although there are a controversial debate on that, public order, like hate speech, public health, morals when it comes to obscenity or pornography. In here, the example of respect of right and or reputation of other, hate speech as well, and also defamation. So when it comes to expression that going to breach or violate all of these limitation or grounds, then we can say that, or the government can say that government should impose punishment or interference by law, by a proper and legitimate law to protect legitimate aim as well, because there are violation to several grounds over here, or maybe just one, depends on the situation and on the offense. This is what I say the restriction or the interference that allow. So connected with the previous slide over here, the manifestation of the violation that I just showed you in the previous slide is over here. Defamation might be attacking honors and reputation, which is right of others people. Hate speech may be also right and reputation of other, and maybe to some extent public order, whenever it lead into a bigger crime or a bigger situation, blasphemy as well, and pornography for public moral. However, I can say in all of this interference or restriction, there are, especially in Indonesian context, most of them, if I can say, or if I'm not to mention that maybe all of them, actually have problematic laws. You may know that currently there are trial going on for two activists or human rights defenders, Haris Azhar and Fathia, because their YouTube video was allegedly defaming Luhut Bin Sarpanjaitan, one of the minister in Indonesian government, and the trial still going on because those two people are allegedly called have been defaming the minister Luhut, which actually when you read the facts and read the case, is actually pretty confusing to how then can this situation be called as defamation, one, and also the situation of the trial itself, which since the beginning it seems like to be in favor to the plaintiff instead of the defendant. So that's the problem in here. Hate speech, if you remember 3 or 2 years ago with the case of Jerings, the SID Superman Setan, how then a doctor profession, medical doctor profession, is considered as part of SARA, suku agama ras antar golongan. While the definition of SARA is actually something that attacks permanently for an individual since he or she was born. So I was born in Malang. So my ethnicity, since I was born, you can say I'm a Japanese. I cannot, even though I move to somewhere else in the world, it will be attached permanently to myself. But different with medical doctor in the case of Jerings, the court think that it's something that attacks permanently. But medical doctor can be, even though it's rarely happen or maybe never happen, but medical doctor can stop their job and then move to other profession. So how come then this medical doctor profession, which because the plaintiff was ED, Ikatan Dokter Indonesia, how come then the court consider this element of medical profession, as in medical doctor, as part of antar golongan? For example, Dr. Richard Lee, who was once a doctor, or maybe still, right now he is a YouTuber as well. Or Dr. Tirta is a businessman. I never know he is practicing his medical license as a medical doctor. So again, I'm just showing the context and the example how then hate speech right now is being abused by the law enforcers in some of the cases. Same with blasphemy, same with pornography. Blasphemy, a lot of cases as well, and even beyond Indonesia, or not just in Indonesia. There is a Professor Ahmed Kuru from San Diego University wrote a book about how then in most of the country that's still having blasphemy law and the punishment is death penalty. This blasphemy law is actually in favor to the ruler or the government instead of the people. So it's actually showing the tyranny of the government itself instead of protecting the religion itself. So that's some of the problem with free speech. Whenever it's actually permissible, but when the law itself cannot be properly regulated, then we have a problem in here. Before I continue, I would like to give couple of minutes in case anybody here would like to ask question, and then I can proceed with it.
Anyone want to ask question? Okay. Nggak ada kayaknya, Mas Eka.
Okay, let me continue then. So the next thing is about the interpretation on the ICCPR. Here's actually there are some interpretation document under treaty bodies itself or under the treaty itself. There are general comments, general recommendation. The latest one is one of the latest on freedom of expression is General Comment 34 about freedom of expression and opinion. It also interpreting that freedom of expression on the internet is also protected. Remember, it is needed or required to having general recommendation or general comment because the treaty itself was drafted and signed in 1966. So it's already been 60 years or so. So the treaty itself, the language of the treaty itself is actually old, not to saying that it's obsolete. So to prevent that to be called out of date or obsolete, hence then it should be interpreted by the treaty body itself, which is Human Rights Committee or the Committee of Civil and Political Rights. Another interpretation from the ICCPR is Syracuse Principle in 1980s actually, but it was providing several interpretation on limitation and derogation, on legitimate objectives or legitimate aim whenever there are interference for limitation of freedom of expression. And it was giving one of the interpretation that could be complemented when there are some cases where state parties of the ICCPR are going to have human rights dispute settlement in the context of free speech, or for example. Now here, what we can take from the general comment number 34 that I just told you earlier, general comment number 34 on Article 19 was actually one of the interpretation on Article 19 of ICCPR. The three-step test here, it's used to determine or to assess whether any interference to freedom of speech or to freedom of expression could be allowed or has been properly regulated by the government, which is the state party of ICCPR. So if you see a case about defamation, hate speech, blasphemy, pornography, whatever it is that based on freedom of speech or freedom of expression, and you would like to assess whether this interference or punishment by the government is properly regulated or not, or has been complied to the international human rights standard or not, the first initial thing that you can do is by applying this three-step test. Okay, I'm going to take one example. Okay, so a couple years ago, 2-3 years ago, there was a lady in Medan who was asking to another lady to paying her debt. So this woman borrowed some money, like 200 million rupiah, and for her husband to become a police or to increase the rank of her husband. And then the lady who has the money tried to asking, please pay your debt. It has been overdue. You have to pay your debt. But then all of her communication blocked by the person who borrowed the money. And then because she doesn't know how to get into the person who borrowed the money, she decided to post on Instagram story. This was a real case. You can Google it. Post in Instagram story that you have to pay your money and then blah, 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 something like that. And then the lady who tagged on the Instagram story and, called out on Instagram story was reporting her to the police, and she was criminally charged under ITE law or UITE for defamation. Later on, after a year of the trial for this case, the lady was verdicted not guilty, so she was free from all of the charges, because the court found that there was no defamation element found, and also there was indeed the lady who reported her was actually borrowed some money from her. So applying this situation, imagine the legality in here is the definition of legality test is that whether the interference or the punishment, to make it simple, the punishment to the free speech violation is already prescribed by law, it's already written by law. In the case, yes, there is ITE law, Article 27, Section 3, saying that someone cannot distributing, transmitting, or make to be cause accessible to defaming someone, attacking honors and reputation. Yes, there is indeed a law which is in Article 27, Section 3 in ITE law. The second step, so it has to be gradually assessed. The second step, whether the law that prescribe or providing to protect, to so-called protecting those free speech and interfering the free speech limitation is actually to be protecting the legitimate aim. The legitimate aim is right here. This is the legitimate aim as well. So whether those law is actually drafted to protecting all of this, whether it's to protecting respect the reputation of others, national security, public order, health, and morals. Let's see in the case. In the case, yes, it was tried to protect someone's honors and reputation. The provision or the language of the Article 27, Section 3 in ITE law also say something about that. But again, we can say that it's to be protecting legitimately. But again, we have to check with the final step test of these three step tests, which is the necessity. Actually, it's not necessity only, but necessity and proportionality. But usually the most common use in this three step test is necessity. So after it is found that it is satisfied the first element, that is legal, there is a law saying it is written in the law. The law itself is served to protect legitimate aim that I just showed you. Can we say that all of this law, that those law is really necessary in a democratic society? Now, referring back to the case, the punishment for the woman, if she was criminally convicted, it will be prison or jail. Now, remember the early facts of the case. It was simply a woman asking to another woman to pay her debt. So it was civil law. It was civil law relation relation between two individuals. How come then state using their resources, using criminal punishment, using the resources as in prison for a private law individuals relationship, which actually simply based on one person calling another person to asking to pay her debt. That's it. So the law in here, the criminal punishment in here, which is prison, jail, or whatever it is, or even death penalty, whenever to some extent on the cases, is not really necessary. It's going to be harming the democracy principle, and it's not proportional as well, because let's say the offense is like this, but the proportional of the punishment is over here. It's beyond there. So it's not properly proportional in terms of the interference or the punishment here. So here is the explanation of the three-step test. Whenever you see a case on free speech violation, one of the things that you can initially do is that assessing this test, legality, legitimacy, and necessity. I already talked about this article 8, 19, and 20. How is the connection between war propaganda and hate speech? Now, before I talk about the case, I would like to give another chance. Is there anyone to have any question? I think I saw.
Ya, Farah silahkan.
I have several questions. First of all, I didn't remember seeing libel in your presentation. Regarding libel made by sometimes news media write misleading articles or fake articles that leads to a defamation of someone's reputation, such as fake news and misleading news, etc. And that is considered as libel. And what do you think of libel? And is it one of the exceptions when it comes to free speech? And the second of all is regarding what you were saying about UU ITE. I have some lawyer friends who handle cases such as those. Like one of the most viral case is the case of this one woman who was talking about how she went to this skin clinic, and instead of getting better, she gets gradually worse because of the clinic. And when she posted about it, she got a defamation suit by the clinic, and it was a very long trial regarding that. What do you think is the right step to make sure that UU ITE doesn't actually criminalize the victim, but instead it criminalizes the offender, or for example, the viral case of the woman with the skin clinic? What can be done to the UU ITE so that it is the clinic that is at fault, not the woman? Thank you. That's my two questions.
Yes, I'd like to respond that first in case anybody has another question. But let me respond with this one. Thank you, Farah. So the first one, I didn't mention libel because libel is actually part of defamation. So defamation has two type of forms: libel, which is written defamation; slander is spoken defamation. So the difference is only on the form. So if libel is written on paper on the internet, that is called libel. While for slander, it is called spoken defamation, something that's spoken directly to the person. Defamation itself is like the induk, or like the bigger cap of these two type of defamation. I understand maybe the confusion, because when you going to find a translation, defamation is going to pencemaran nama baik or penghinaan, but it's not compatible when we found it in English. Any law in English, it's not really compatible. But I mean, it's a problem of language actually. Slander itself, when I did my research, when I tried to find the translation, it's called fitna. Fitna itself, it has a separate provision in Article 311 of KUHP, the current KUHP, not the one that's going to be enforced in 2026. So to answer your question, that would be libel defamation. I think all of the elements that cover in defamation is actually also practically applied in libel as well. But again, to emphasize that libel is written defamation. So right now, let's say if someone have been defaming someone on newspaper or on the internet, it will be called as a libel. But this term actually with the internet advancement, it has been rarely used, even in some developed country as well. There are libel laws, but most of the time people usually call online defamation or offline defamation. But yes, it is still a valid term to call libel whenever to get defining written defamation. That's number one. Number two, I don't know if the same case that you're talking about. A year or 2 years ago, there was a case in Surabaya about beauty clinic customer, and she was also reported to the police and criminally charged, but she was eventually found not guilty by the court. The first step, I'm talking about the ideal one. The ideal first step if there is a case like this is then using the 1999 Consumer Protection Law, Undang-Undang Perlindungan Konsumen. Same with one of the early case of ITE law in 2008 with Prita Mulyasari. In case you haven't heard, you can Google it. Prita Mulyasari was also a customer of hospital. So similar case, she was mistreated. She called that there was a mistreated. Same with the case that you just told us. So she was simply told to the public, complaining about the service. Well, maybe there is let's say there is a better way to complaining, yes. But even though the method of complaining is not correct, as in the business owner did not accept the way of this customer complaining by using social media, people just cannot use ITA law to abuse the freedom of expression of someone, because it's merely critic. It's merely criticism. You can just not reporting someone just because you feel offended. Remember what Ricky Gervais said, one of the comedians from UK. Just because you feel offended doesn't mean you are right. Just because you are offended doesn't mean you are right. So in this case, it may be correct in your friend's case that he or she dealing right now. Maybe the customer is the one who right, but then the business owner did not accept the way of this person using the critic. Then that's happened. So I would say, again, to answer your question, I would say the first step that can be taken or can be done is applying the Consumer Protection Law, 1999. The problem is, in most of the cases, and has been evidence show in a lot of customer protection case, supposed to be customer protection case, including the one in Surabaya that I mentioned, and also Prita Mulyasari, and also 2017 there was also case with Muhammad Priacho, stand-up comedian, who complaining about apartment renting, that he was getting bad service as well, and then he was reported to the police as well for defamation under ITE law. So just showing all of these three, just telling you all of these three examples is actually showing that ITE law itself has been abusing a lot of things, including freedom of expression as part of the human rights. Not one, but I mean, there have been a lot of attempts or a lot of efforts to revoking the provision and revoking the ITE law itself. However, unfortunately, the last one that we got is only the SKB-UITE. It was merely guideline, not legally binding. And it is a guideline for legal enforcer, for judges, the court, for prosecutor, kejaksaan, and for the police. That's it. So what it means to the language of the provision itself, because it's not changing anything. So when you read the case of Haris Azhar and Fatia that I just told you earlier, if you're referring to the SKB-UITE research report, which based on their YouTube that they're talking and then reported to the police because defamed Minister Luhut, it was actually from a research report. And according to SKB-UITE, it's supposed not to be called as a defamation if it's based on research report. But still, the minister in here report both of them for defamation. And then we have a problem because, again, SKB-UITE is not legally binding. So the ultimate solution would be a total revision of the ITE law. But right now, it's still going on. So 2008 is the first ITE law we have, and then it was partially amended into 2016 for the amendment of ITE law, but it's only partial. It only changed the I think the only change that I can notice, one of the only change I can notice from 2016 version is that reducing the criminal punishment from 6 years for the prison to 4 years. That's it. But still, the prison term still over there, which is not proportional. Okay, so I think I have been too long to answer your question, but that will be the answer for your question. Anybody else? Let me continue then. Okay, this is showing several cases. So I've been talking about example of the cases in Indonesia. So let's take it beyond because the topic is international human rights law anyway. So I'm going to talk or giving you several example real cases that happen in other countries or region. So the first case was happened in 2007, I think, in European Human Rights Court. I forgot the full name, but last name is Balambala versus France. Balambala is a comedian or stand-up comedian, I think. And then in one of his comedy show, he was initially talking using stage act in comedy, and then at one point he took it too far by making public insult against Jewish people. The way he did it is that he invited one of the academician, real academician, I think a professor in university, and then talk with him about whether Holocaust is real or not. According to Article 20 ICCPR that I just showed you earlier, glorifying crime, denying crime, such as in Holocaust, is also not protected and would be violation of Article 20. And he is what he did according to European Human Rights Court. He invited the person, the academician, and also he used some ornaments that reflecting mocking or insulting the Jews or defaming Jewish people in here. So when he reported to the police and then before the court, Balambala was trying to argue or claim that this is my freedom of expression, but the court rejected because the court think that he has been abusing his freedom of expression, because when he do the public insult by inviting the academician, talking about denying Holocaust and attacking Jewish people, and also using the ornament that mocking Jewish culture and Jewish people, the show is no longer about comedy and entertainment. It's no longer about satire, but it become hatred expression or become hate speak, which is, of course, can call it hate speak according to Article 20, war propaganda as well, or propaganda or glorifying crime as well, or hateful speaks in here. So that's why the verdict was he was guilty especially for this article in European Human Rights Court, prohibition of abuse of rights. That's the first case. The second one is happened in our neighbor, Malaysia. So this person with the long hair is a law professor in University of Malaya in Malaysia. In 2014, he was arrested for sedition. So sedition is, let's say, if makar or treason is, attacking government. Sedition is inviting people or menghasut, as in inviting people to become opposing to the government. And this person was arrested and was almost going to criminally charged for sedition law in Malaysia, just because he's saying this. So he was interviewed by one of the media in Malaysia, and the media was asking his opinion as a law professor, because he is a professor of constitutional law, hukum tata negara, and then he was asking about, what do you think about the parliament doing right now in 2014, nearly the election? The government at the time was going to have a secret meeting, and his statement was actually referring that there was another situation that's similar, where government hold a secret meeting, and it was actually violating the Malaysia constitution. And he was simply saying this statement. Well, the whole article or the port of the article is over here. He was simply saying that what happened in Perak, the first incident, was legally wrong. So he was not mocking or asking other people to opposing government. He's using his expertise on constitutional law and the Constitution of Malaysia, saying that it was legally wrong. Still, then he was reported to the police and then called as doing or did sedition or conducted sedition to the Malaysian government. However, he was finally free of charge because all of those criminal charge and sedition, because the law itself is no longer constitutional, and then the law is no longer valid to be imposed to him, and then he is free. But it was after 2 years of the trial before the court. So he was arrested in 2014, but not until 2016 he was free from all of those charges. The charges were dropped. The last one, just very simply, last for the case and last for this lecture or presentation, is that especially in countries in Asia or even Southeast Asia, like our country as well, Indonesia, lèse majesté, or defamation against the government, or defamation against the king, or defamation against whoever the leader of the country is still a fault. It still exists, and this is a pretty good example how a Thai man in Thailand is sent to prison for 2 years because he sold a calendar with the icon of yellow dove. Yellow dove is a icon to being opposed to the government, because there was a lot of imbalanced political situation in Thailand as well. But it was say that selling the calendar is mocking the king. Instead of that, it was part of political speech of this person, which is part of the freedom of speech of this person. Therefore, we have 3 of the cases, and also the cases that I talked in Indonesia. I think that will be all from me, Bu Siska. I'm turning back to you. Thank you.
Thank you, Dr. Eka. Maybe for all of you, you have any question or comment, you can ask now. Anyone want to ask? Boleh bahasa Indonesia. Karena ya silahkan, boleh bahasa Indonesia, boleh bahasa Inggris, boleh di chat box. Silahkan. Mumpung ya, expertnya freedom of speech. Jadi kalau kalian mau tanya-tanya silahkan. Apa saja, ya enggak masalah, silahkan. Ada yang mau tanya? Ya, silakan Diva.
Before that, I'm sorry if this question is a little bit abstract. I would like to ask about how some governments sometimes they criticize back to the advocates, such as untuk kasus example-nya Munir Said Talib. Munir Said Talib mengkritik banyak tentang pemerintah, dan jadinya beberapa pemerintah tersebut justru karena mereka nggak bisa langsung mengkritik dan saat itu tidak ada undang-undangnya untuk UU ITE seperti hari ini, jadinya mereka mengatakan hal-hal seperti, oh nggak usah didengarkan, orang ini Yahudi, atau orang ini juga termasuk teroris. Does that have no consequences in if the government did it, even today, right now, and the netizens back them up? Because our course of law is being influenced by netizens too. So if netizens defended the government and the government said something like hateful, such as attacking the religion of someone, the race of someone, does that not be dangerous to the law, to the society, to the what's your take on this? I'm so sorry if this question is a little bit of a mess. Thank you.
Yeah, thank you, Diva. So I don't think the question is abstract at all. I think you gave a pretty good example and clearly articulated what you meant by the question. So I'm gonna give 2 level of answering to answer your question, 2 level of argument to answer your question. The first one is about, I would like to introduce, in case all of you here haven't heard, the term of marketplace of ideas. So you might ever heard marketplace as in, e-commerce, whenever you go and check out on Shopee or whatever it is of the platform marketplace. It is actually a metaphor for free speech. Marketplace of idea is like when you are selling an ideas or information in a marketplace. So this metaphor was actually coined by Justice Holmes in 1919 or 1920s in the US. So it's from United States jurisprudence actually. So he was arguing that free speech is actually like marketplace of idea, where everybody can sell their ideas, can sell their opinion. To apply this metaphor to your question, is that when someone criticizing the government and the government criticizing back, that is actually the ideal response that we are hoping to. So in the case of, let me use another analogy in Haris Azhar and Fathia to Minister Luhut. Whenever Minister Luhut did not accept their criticisms about, that Minister Luhut is having play a role in this tambang in Papua, then he should not reporting back to the police, but he should criticizing back. Where's the evidence? Where's the proof? I don't think the research report that you use as a reference is a valid one. I have my own proof that I'm not part of that business. It should be the first initial response from the person, not by reporting these two persons, human rights defenders, which is actually also violating human rights law and also environmental law as well, because it's part of this area as well, to the police. And then here now we have the trial of that situation. So when criticizing respond by criticism as well, it's still okay. But the second level I would like to answer is that when you say, what if the government is in here is responding by attacking the religion or something personal, then we have to be careful to determine whether it is a criminal offense or not. If it's still like personal, as in insult, like insulting, like oh you are, like you said, you are Jewish, or you are a Jew, or you are Yahudi. If that happened to me, I don't think it doesn't matter at all, because I'm not. Let's just say that. The problem is insulting or penghinaan ringan is still a criminal offense in our KUHP 315. So all of those penghinaan ringan that not attacking our honors and reputation, that's not affecting our reputation, our kehormatan and nama baik, is still considered as defamation. How come? If you call me, oh, you're a fat ass, then I can report you with Article 315. It's supposed not to be a criminal offense whenever it comes to those. And most of the country in the world, well, many, not most, many countries in the world is no longer use insult as part of criminal act or criminal defamation. However, we still have this example. One real example of the case. If you remember, I forgot the name of the celebrity. There was a celebrity that called by another woman that, I'm sorry, his genitalia is like ikan asin, and then this lady reported to the police. It wasn't attacking her honor and reputation. It was simply insulting, and I believe it's not true. I believe that wasn't true. And how come people use this insult from one person to another person, which is like simply people mocking each other? Oh, you ugly, your face is like a dog, your face is like a monkey, and then use defamation law, use public law, use criminal law, use the state resources to report this person just because you feel offended. Of course, this is not correct, right? So here is the second part of the answer, because if it's still on the line of just critic versus critic, then it's still okay. But whenever it comes to the personal thing, we have to be careful to determine. It depends on the expression. Hope that's answer your question.
Oke, mungkin ada pertanyaan lain? Ya, silakan Adrian.
Izin Bu bertanya, dan izin menggunakan bahasa Indonesia ya, agar tidak kesulitan untuk bicara.
Ya, boleh.
Ya, untuk pertanyaannya ada dua. Yang pertama itu tentang tadi yang disinggung adalah lese majeste, itu entah prinsip atau teori ya, yang mana intinya serangan terhadap kepala negara itu kan dilarang. Dan di Indonesia setahu saya masih ada di OP yang baru sekalipun, yang itu pernah menjadi perbincangan antara Prof. Yaris dan lawan bicaranya. Itu apakah lese-maese ini tidak bisa diconsider, tidak bisa dianggap bahwa itu sama buruknya seperti defamation, blasphemy, dan pornografi, dan satu lagi yang saya lupa tadi. Apakah itu tidak sama-sama kuatnya gitu loh? Yang mana yang poin saya adalah lese-maese ini bukankah membatasi freedom of speech, yang akhirnya kepala negara, dalam hal ini Presiden Indonesia, adalah itu tidak bisa dikritik karena sebagai kepala negara, padahal Presiden kan juga sebagai kepala pemerintahan, yang mana di dalam kapasitas sebagai kepala pemerintahan itu pasti seringkali bisa dikritik gitu loh, punya ruang-ruang untuk dikritik. Itu yang pertama. Dan mungkin yang kedua tentang aktivis yang dikriminalisasi, dan yang mana aktivis, contoh kasus yang tadi diberikan adalah kepada Pak Luhut ya, Pak Kepala Menteri, itu apakah seharusnya bisa yang mana polisi itu bisa melakukan kontrol yang terhadap atau against government, yang mana kritik ini kan dilontarkan ke pejabat publik, yang mana pejabat publik itu akhirnya meretaliation dengan melaporkan secara pidana gitu. Apakah logical atau rasio legalnya itu lurus kalau polisi ini membuat suatu mekanisme yang mana apabila pejabat publik yang melemparkan pelaporan ini akan diperberat atau dipersulit untuk dilanjutkan, karena lagi-lagi demokrasi ini kan kedaulatan di tangan rakyat. Kalau rakyat sendiri dikriminalisasi, bagaimana kontrol publik atau partisipasi publik bisa berjalan? Mungkin dua pertanyaan itu yang akan saya tanyakan. Terima kasih.
Iya, saya respon sama bahasa Indonesia ya, karena ditanya dalam bahasa Indonesia. Oke. Jadi lupa tiba-tiba. Yang pertama tadi, maaf,
Tentang
poin
lese-maese.
iya, lese-maese. Jadi lese-maese itu sebetulnya dari Prancis, kalau saya nggak salah dari Prancis, dan memang bahasa Prancis. Artinya kurang lebih kan majesty itu majesty, jadi serangan atau penghinaan terhadap yang mulia gitu loh. Yang mulia di sini maksudnya raja, ratu, siapapun yang memimpin di kerajaan. Ya, itu sebetulnya ya hukum yang sudah berlaku di zaman dulu di Prancis dan juga mungkin negara-negara Eropa lain, yang kalau konteks sekarang itu ya seperti tadi sedition tadi, atau penghinaan terhadap kepala negara yang seperti itu. Jadi itu sebetulnya sama seperti defamation, cuman bedanya adalah yang diserang siapa gitu. Sebetulnya sama dengan defamation, tapi bedanya adalah tanda kutip korbannya. Bilang korban itu harus pakai tanda kutip kalau lese-majesty, karena yang diserang, yang tanda kutip diserangnya kan orang yang punya power. Nggak mungkin lah dia jadi korban kalau punya power, kan gitu sebetulnya kalau kita pikir secara logika. Jadi kenapa kemudian tadi saya bilang cukup masih banyak di negara Asia, khususnya Asia Tenggara, dan tadi saya ambil contoh di mana Thailand, ya karena memang itu yang terjadi. Dan nggak cuma Thailand, di Malaysia juga begitu. Di Malaysia itu waktu COVID itu ada, kalau baca kasusnya konyol lah kalau jadi ada seorang laki-laki aktivis seniman, dia bikin playlist Spotify yang judul playlistnya itu Dengkike. Dengkike itu dalam bahasa Melayu kalau nggak salah artinya kamu iri ya gitu. Nah, kamu iri ya ini merujuk pada satu pernyataan di mana waktu itu Ratu apa Perdana Menteri ya. Pokoknya istrinya kepala negara Malaysia itu dapat vaksin COVID duluan. Jadi sebelum rakyatnya itu divaksin, malah dia dapat duluan. Nah, terus orang-orang protes. Balasannya begitu, kamu iri ya gitu. Saya dapat duluan. Bayangin coba. Nah, karena iri, nah karena dianggap iri dan dibalas begitu, nggak, orang-orang ini nyindir, bermain sarkas saja, bermain satir menggunakan playlist. Lah kok dia dilaporin sama sedition lagi. Nah, inilah kenapa yang saya bilang tadi, lese majesty yang di Eropa itu udah banyak nggak dipakai, sekarang malah makin berkembang dan makin banyak di negara-negara Asia, khususnya Asia Tenggara. Indonesia walaupun bentuknya bukan kerajaan, tapi kan kelihatan kan dari bagaimana kasus ini berjalan, bagaimana kemudian sebegitu powerfulnya pejabat publik yang kemudian, kalau Anda baca kayaknya sih terakhir 2019 atau 2018 ya, laporan tentang berapa persen yang melaporkan pakai UU ITE itu hampir 30-40% itu pejabat publik yang melaporkan UU ITE pasal 27 ayat 3. Itu yang terakhir 3-4 tahun lalu ya. 18 atau 19. Nggak tahu yang sekarang mungkin ada yang terbaru. Nah, waktu itu baru UU ITE baru berapa tahun aja, tapi sudah ada hampir 40% pejabat publik yang melaporkan. Artinya kan sebetulnya ini masalah yang walaupun kita nggak terang-terang disebut laissez mayas, tapi itulah yang terjadi. Jadi tadi ketika sempat disinggung debat antara Prof siapa tadi ya saya, dan kalau saya nggak salah itu kan menjelang waktu rame-rame cabut UU ITE tahun lalu kalau nggak salah, sama juga KUHP. Ya saya sependapat karena memang itu yang terjadi gitu loh. Itu yang terjadi bahwa laissez mayas itu sebenarnya sesuatu yang sudah usang, tapi di negara Asia, di Indonesia bahkan dipakai kembali gitu loh. Bagaimana mungkin raja yang sudah terhormat, pemimpin negara yang sudah terhormat bisa merasa kehormatannya hilang atau ternodai hanya gara-gara omongan atau kritik warga negara yang jauh sebenarnya statusnya itu kan jauh gitu loh. Secara kalau kita perhatikan sebenarnya statusnya kan jauh, atau punya power atau yang enggak gitu loh. Nah itu abusive of power itu di situ. Nah nyambung ke pertanyaan kedua adalah kemudian bagaimana ini juga menunjukkan tadi bagaimana abuse of power-nya. Nah saya mau pakai satu metafora lagi, bukan metafor prinsip hukum sebenarnya, tapi ini ada kasusnya tahun 67 di New York Times versus Sullivan di Amerika Serikat. Namanya actual malice. Jadi seseorang kalau misalnya dia pejabat publik merasa terhina, actual malice ini akan digunakan, standar actual malice ini akan digunakan untuk kemudian menguji apakah betul ekspresi dari orang yang dianggap menghina ini menyerang dan memberikan dampak kerugian atau kerusakan yang nyata terhadap reputasinya. Makanya namanya actual malice, kerusakan yang nyata atau benar-benar terjadi apa enggak. Caranya gimana? Dari beberapa, kalau di kasus itu dari beberapa cara yang dipakai, karena itu kan New York Times kan koran, Sullivan ini kepala wali kota kalau nggak salah, wali kota di Alabama, bisa wali kota di Alabama. Cara yang dipakai adalah apakah kalau konteksnya koran di kasus ini, apakah pemimpin redaksinya itu tahu kalau iklan yang ditampilkan yang dipermasalahkan itu memang benar-benar dengan sengaja udah tahu salah tapi dengan sengaja diterbitkan gitu. Atau mereka nggak tahu tapi ada kelalaian di sana. Jadi dua unsur itu dipakai dalam konteks pidana, dua unsur dipakai gitu. Nah, diterapkan di situ. Nah, standar actual malice ini menjadi lebih tinggi kalau dia pejabat publik. Kalau dia sama-sama orang biasa yang lapor dan dilapor, itu nggak dipakai. Inilah yang nggak dilakukan di dalam kasusnya Haris Azhar sama Fathia, sama tadi Mas Adrian bilang kepala menteri. Saya suka itu istilah kepala menteri. Karena standar itu nggak dipakai ya. Memang sekali lagi saya tahu bahwa ini dari Amerika, tapi kan formulasinya kan sebenarnya bisa menggunakan yang berbeda. Bisa menggunakan istilah berbeda. Itu kan sebenarnya suatu hal yang logika dasar lah. Kalau memang seorang pejabat publik itu sudah punya power, kenapa dia masih diberikan kewenangan yang cukup lebih? Bahkan kan sebetulnya kalau baca beberapa fakta terakhir menjelang persidangan, kan sempat ada mediasi, tapi Pak Luhut yang nggak datang untuk klarifikasi, yang mana kalau mau ditelusuri lebih jauh, kalau konteksnya masalahnya dari konten media, kan sebetulnya bisa menggunakan hak jawab dan sebagainya. Direspon dengan kritik tadi seperti pertanyaan jawaban saya ke Mbak Diva tadi, itu kan harusnya itu dulu, baru kemudian mediasi dan lain-lain. Tapi kan ternyata itu nggak terjadi, nggak dilakukan, atau mungkin nggak terlaksana dengan baik. Akhirnya ya udah pelaporan sampai sekarang berlanjut, dan terakhir malah eksepsinya ditolak. Jadi putusan selanjutnya menyatakan ya ini tetap lanjut sama hakim gitu kan. Itu kan sebenarnya jadi masalah juga untuk hal semacam ini. Jadi ya itulah jawaban saya untuk Adrian, mungkin seperti itu.
Terima kasih atas jawabannya.
Ya. Ada lagi dari mahasiswa sekalian? Oh ya, silakan Devita.
Baik, terima kasih Bu. Mungkin pertanyaan saya lebih simple dan lebih ke arah kepo aja sih Pak. My question is, as everyone probably know, the media platform called Instagram, there's this one user who's very much famous called Bella Hadid. She is a model from the United States and she is currently staying in the United States. I remember seeing her Insta story saying that she's shadow banned by Instagram and she can't access her DM and she can't post anything. And she says, and this is her words, she types it and says that she assumes this only happens whenever she posts things relating or even mentioning the word Palestine or things that is happening on Palestine. My question is what Instagram did, because Instagram thought that it's against the guidelines, is blocking or hindering the freedom of speech that Bel Hadid has? And is it part of the limitations of freedom of expression that Bapak Heka has mentioned before? Thank you.
Thank you for the question, Devita. It's a simple and not simple question actually, but thank you too. Bella Hadid, I do not really know the detail and the facts of this situation. I don't think I could not call it case because as far as I can remember, it wasn't going to court or trial. But anyway, yes and no. Yes, that it may be a violation to her freedom of expression whenever she tried to post something about Palestine and the human rights violation over there, and the occupation by Israel and those kind of stuff. But we also have to check what kind of posts she shared, one, and also what kind of what is the community guideline of Instagram says about that. If it's something like let's maybe again, I'm saying this because I do not know the real details of the post and situation. Maybe the one that she posts is something like very bloody and gory of violence, so it maybe violated the community guidelines. Maybe there was a Palestine kids that getting attacked or getting shot, and then she posts that is bloody and having those kind of gore and violence, and then Instagram could not accept that and call it as a violation of her account, and then it may be justified. However, if it's something else, then I cannot assume that there is something going on beyond that situation, because I have one of my friends when I study my doctoral study in the US is from Palestine, and he regularly posts what is happening in his country until now. He is still living in the US right now, and his post never got blocked or his account never got suspended. And his name is Nazir, and originally from Palestine. So, and I don't. I mean, compare these two people's situation, Bella Hadid and also Nazir, my friend over here. I don't think something that we can suspect here. Maybe maybe yes, maybe no. But again, it depends on the post itself. But if we would like to having a suspicion over the situation on Bella Hadid, as you asked, maybe it was violated because Bella Hadid, has many followers compared to my friend Nazir. Nazir only has 1,000 followers, if I'm not mistaken. But Bella Hadid, I think, millions of followers. So maybe that's the problem here. To give you analogy, in Convention on Elimination of Racial Discrimination, CRD, in General Comment of 35 of the convention, racist hate speech, it's not a compatible one to be as an analogy, but maybe it can give you context. So racist hate speech should be determined more seriously whenever the person who say the hate speech or who spoken the hate speech, expressing the hate speech, is influential. That is what it says in the general comment of CRD. So it may be also the problem or the situation that happened in Bella Hadid. I do not know again, but what can I only have is assumption and guessing about the situation. But again, I hope that answering your question.
Okay, maybe the last question, anyone? Pertanyaan terakhir ada? Kalau memang tidak ada, mungkin saya akhiri ya, Pak Eka. Thank you so much for coming to 3-in-1 class, especially in International Human Rights Law class. Maybe we only have like 11 students, but I hope all of you can understand what actually freedom of speech itself. We also maybe you can find something that you can use for your thesis. Maybe. Yeah, thank you so much. Mungkin bisa ketemu lagi Pak Eka di kesempatan yang lain, dan juga mahasiswa sekalian masih ada pertemuan di minggu terakhir. Nanti untuk kasus selanjutnya, ya tadi ada Bu Ulan yang memanggil, mohon maaf. Ya, terima kasih sekali lagi. Akhir kata, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Terima kasih ya.
Makasih ya Eka.
Ya, sama-sama, makasih.
Terima kasih.
Semoga nanti ada lagi kalau masih berkenan.
Siap. Terima kasih.
Terima kasih.
Terima kasih.
Salam.
Terima kasih Mas Eka. Ya, wis silahkan log out.